Okay, let's go back to arbitrators. You said earlier, arbitrators they are sort of judges. I mean, we can say that they are judges. Who chooses and is there a certified list of arbitrators that parties can choose from? Or,
yes. In the IPO field, we did an accreditation program for the arbitrators, and we invited IP lawyers, IP experts, and arbitration experts. And those arbitration experts were trained in IP. Those IP experts were trained in arbitration, and jointly they were trained by the World Intellectual Property Organization for specialized arbitration on IP cases. We actually asked them to sit in 4-hour examination to complete the accreditation, and we're going to release the official list of those who were fully accredited as IPO field arbitrators.
Okay, so we'll get back to that list of accredited arbitrators/judges after a traffic and weather update from Charlie of Traffic.com.
We now return to Piracy Watch on DZRJ 810 AM.
All right, welcome back to Piracy Watch with me and Attorney Lope Manuel Jr., the head of the Arbitration Office of IPOFIL. Okay, just for a news break, researchers from the Mindanao State University Iligan Institute of Technology, Marawi, and Naawan converged yesterday, and tomorrow in Iligan City, Lanao del Norte to undergo a patent drafting seminar. According to Mindanao State University Chancellor Marcelo P. Salazar, this seminar will equip our researchers to prepare applications for patent protection over their inventions and innovations. The IPOFIL delegation consists of Ms. Rosa Fernandez, Engineer Chamlet Garcia, and Engineer Eric C. Padon. Okay, just before the break, we were talking about arbitration and how it is an alternative mode for litigants out there to go into instead of going into the courts. This way, you get the results that you want, and you get to choose the judge, the venue, and the hearing dates. Okay, now, for judges or the arbitrators, you cannot just choose any judge. There is a certified list that the IPOFIL has from which litigants can choose from, and these arbitrators is it proper to call them judges?
No, because we want to separate them from the regular proceedings.
From the regular proceedings.
And plus judges are appointed by the court, right?
By the court, yeah. So it is an alternative mode of resolving cases, but they are not necessarily called judges. They act like judges in the meantime that the arbitration proceeding is in front of them, but the proper term is called arbitrator.
Arbitrator, yes, because you can still practice law if you want. You can still teach law if you want. You can still go ahead with your own life. You don't have to be a lawyer to be an arbitrator.
I don't have to be a lawyer.
Yes,
so you can be like a former CEO. Is there an age requirement? I mean, young people like us.
Unfortunately, we're not qualified because you have to be at a certain age, and sometimes even if you go there at a very young age, no one will trust you. No one will appoint you, right?
That's exactly what I'm picturing. For example, I'm a big franchise holder. I'm suing a franchisee here in the Philippines. I don't want my arbitration case. I don't want to hire someone or get someone who has no experience in commerce.
Exactly. Yes, exactly. So the people that we have chosen in the pool are experienced lawyers, businessmen. Some of them are engineers, scientists, patent experts, so that we will diversify the number of people there, the kind of talent that we have. So you can choose. For example, if your problem is patent, of course you want to know, or you want to have someone who understands what is patent, right? You cannot just choose a lawyer. It doesn't matter if he is a retired justice of the Supreme Court or something. If it doesn't understand patent, it doesn't give you any advantage, or it doesn't give you any comfort when you're litigating or arbitrating a certain case.
What is the success rate of arbitration cases?
How many cases actually the success rate is based on the enforcement of the award. Usually the parties at the end of the arbitration, there will always be an award. Someone will win, someone will lose. It's the same way as a court litigation. And the test whether the arbitration is successful is if the award has been enforced. And for example, in most countries like Singapore or in Hong Kong, the success rate is almost 100% enforcement. And here in the Philippines, we are partnered not just with the Philippine Dispute Resolution Center, but also with WIPO, specifically to ensure that the decision will be enforced. And if you check out our rules, we have a scrutiny provision there, which means that when an arbitrator, a panel, or an individual arbitrator issues an award, it will be reviewed by the IPOFIL, a group of experts, just to make sure, for example, if there's a violation of national policy or public policy issues, because IP is not just the regular criminal
Yeah,
case
yes.
or a family court case or something that you can just rule on whatever and then it will be enforced. There are issues that we IP lawyers know that are not familiar with even the smartest lawyers that doesn't practice IP, right? So we have to make sure, for example, that you're dealing with that your arbitral award, your decision will be enforced in the court. It will not violate any provisions in the IP code.
There are examples of violations of public policy. Or for example, someone discovered a cure for cancer, and I don't want to license it to anyone. And then there's an arbitral award to that effect. This is all hypothetical.
Yes.
For example, the arbitrator upheld my right not to disclose or license my invention that cures. I mean, my medicine or the drug that I invented that cures cancer. What will the arbitration? What will the court do to enforce or not enforce that arbitral award? For example, the arbitrator upheld me. I mean, meaning. I will not license my drug. I will sell it for a very, very high price, for example. So there's a public policy there in the sense.
Yes, exactly. Well, the scrutiny provisions in the arbitration rules of the IPO tries to avoid that situation. Before it is released, the IP experts in the IPO will know, for example, if there will be a national or public policy issue concern. Like, for example, in your case, if we come up with a decision like that, we will deliberate and we will tell the arbitrator that, hey, this is something that will most likely not be enforced by the court if you issue this. But Sarah, we have to understand that the arbitrator, they have an authority to issue the award whether or not this will violate public policy. But in most cases, like the one in London or New York or even in Singapore, you do not dare ignore the people in the scrutiny desk, right? Because you will never get appointed.
Again,
once you
as arbitrator.
Yes. And of course, maybe it's not, we don't want to highlight this, but this is very lucrative practice in other countries for the arbitrators, yes.
Because they're private judges, more or
yes,
less.
exactly. And then you get your fees based on the amount involved in the case. Like, for example, a judge who's supposed to be earning a fixed rate
from the government.
Yes, a fixed
also,
salary.
arbitrators earn their income from the parties.
From the
at least from the it's a percentage of the
It's
award.
a percentage of the, not really the award, the
really.
amount involved.
The amount involved.
And then there's also a provision if the issue is very complex, like maybe you need a scientist. Of course, you cannot just pluck out a scientist from UP, right? You have to pay him, you have to compensate him the right amount of money. So we have a provision that, okay, if you act as an arbitrator, you will be paid this much. Could you just imagine a top litigator, like let's say, I'm sorry, but Attorney Lasatin is one of the top litigators in the Philippines right now.
Attorney Lasatin.
Yes, you cannot just pluck him out of his practice and tell him to sit as an arbitrator if there's no incentive. Of course, you're hiring an expert like that. You're hiring someone who's knowledgeable about almost everything related to the law. You have to compensate him the right amount of money for him to do the job.
So how can you, let's face it, one of the more common complaints in our judicial system is the corruption of judges. So how do you ensure that the arbitrators don't get, corrupted? Well, first of all, both parties pay for the arbitrator. So they share the expense of paying the arbitrator. Second of all, you said earlier that some arbitrators are IP lawyers. So will they be, what if one of the parties is a former client? I mean, do you disqualify those arbitrators from handling cases in which they have an interest in?
There are disqualification procedures for appointment of arbitrators. And you have, for example, if I am appointed as an arbitrator, I have to make a disclosure of anything which might relate or which might put my reputation in question. If, for example, I am related to one of the parties, or if I acted as a counsel before, or if I'm familiar with a case, I ruled on a case similar to this, or anything which might relate to a conflict of interest. But
you have to
you have to disclose that. But the thing here is, Hara, is that all the parties, they given the opportunity to appoint the arbitrator. The Party A will appoint an arbitrator, Party B will appoint an arbitrator, and the two appointed arbitrators will appoint the head arbitrator. So
between themselves,
between
the two of them, or they choose someone?
No, they choose someone else. Like it could be a panel, right? So if, for example, I'm choosing an arbitrator, I have to make sure that this person is reputable, that
and it's
neutral. It's neutral. And I just have to clarify this right now. You cannot choose someone related to you or your friend or something
to be your judge. Yes, you cannot do that.
The arbitrator is you choose an arbitrator that you're confident about his talent, about what he can do,
About
and
his
he's not
knowledge.
representing you. You are appointing him in the panel just to make sure that you have someone there that you're confident with. But he's not going to represent your interests. He's not going to debate or lobby the case for you in the panel.
Once I appoint or parties appoint an arbitrator, it doesn't mean that the arbitrator is their counsel.
Yes, exactly.
It means that you voted for that guy, you chose that guy jointly because you can trust that guy to render a neutral and a fair decision. Yes. But litigants have to be represented by lawyers.
Yes, they have to be represented by lawyers, or they can. This is a private. What do you call a setup? You come up with how will it be litigated or arbitrated. You come up with your own rules if you want to change or tweak some of the rules according to your preference, and you choose a time, you choose a venue. Everything it can be adjusted. In fact, you can even be represented by a non-lawyer, provided of course you follow the rules on a person representing someone in an arbitration proceedings. Like, for example, a foreign lawyer cannot, just go to the regular courts. That's the only time that he can appear. In the same way that, for example, if you want to be represented by a non-lawyer, you follow the rules of court for that.
So you can choose who will be your lawyer, or you can choose to be present in the arbitration proceedings, represent yourself.
Yeah, it could be done. Like maybe you want to be represented by a scientist. You're debating on some medicine or something like that, discovery, and you want to prove that you were the first, right?
But how long does it take for arbitral cases to be resolved?
That's the beauty of this procedure, Sarah. You can choose, for example, a hearing that would last for like 2, 3, 5 years, but you can make it as fast as 2 months or 3 weeks or 1 week or 1 day.
So it's very fast. I can just, okay, let's settle this. I don't want you as my franchisee violating my rules. Let's agree on 1 month. Let's hear out each other.
Exactly.
And then
Yes.
finish it after
Or
1 month.
sometimes you can agree that, well, we're not going to have a hearing. We're just going to submit all our position papers and leave the arbitrators to decide.
So you don't need to pay appearance fees anymore to your lawyer. You can just pay them for the pleadings that they're going to submit to the arbitrator.
Exactly. But most of the time, especially for specialized cases like this, you want to have a hearing. Like this is specifically advisable for cases that time sensitive, or those related to trademark secrets or trade secrets, like the one you mentioned before, like McDonald's, if they have a special recipe for a burger, that is something that you want to be very confidential and you don't want it to be released in public documents. And once you enter the court, once you enter the public system, everything becomes public. But here in the arbitration, you can choose, you can manage that situation by making everything confidential. Even, for example, the experiments, the trade secrets, you can make people sign a contract, or you can do the arbitration proceeding in a closed door, very, very confidential setup that no one will come out. Nothing will come out of your trade secret.
But can you record, usually in courts, you record the proceedings. There's a stenographer, and then they type every word that comes out of anyone's mouth. How about in arbitral
Yes,
cases?
you can actually do that. But
you can also do away with that.
You can also do away with that. You can request it.
On the parties.
It's very flexible. Like if you've seen the Social Network case,
The movie?
right? The movie, right?
Yes.
It doesn't look. Yeah, it doesn't
case.
look like a court hearing, right? They're just in a law firm. They're interviewing themselves.
That's an arbitration.
That could be an arbitration setup. I would imagine they did not say that they're going to enter into arbitration. I believe that they use terms such as deposition, like before the court, you enter into this court hearing and all of that, and you present all of that in a court. But I think it could be an arbitration proceeding.
That is how an arbitration proceeding looks
yes,
like.
Yes.
So for those of you who watched the Facebook movie called The Social Network, Mark Zuckerberg was actually undergoing trial there and he was presenting evidence before a panel.
Yes, you don't see judges, right?
Yes,
you don't
and he knows
see
the judges. Yes, he was. Sometimes he was disrespectful to them and everything. But that is the kind of flexibility offered by arbitration.
Yes.
Okay, so we're going to hear more about this, as I said, revolutionary way of settling your cases when we come back on Piracy Watch.
We now return to Piracy Watch on DZRJ 810 AM. The voice.
All right, ladies and gentlemen, welcome back to Piracy Watch. Attorney Ricardo R. Blancaflor, Director General of the Intellectual Property Office of the Philippines, aims to move responsible destruction of pirated goods up the political and judicial agendas. In a paper presented before the 6th Global Congress on Combating Counterfeiting and Piracy, held last Feb 3 in Paris, France, Attorney Blancaflor stated, "It is part of our responsibility